There are, in fact, more and more documents in the Idaho 4 case, but you know what? There's really no more actual information.
The world is on the edge of their seat, waiting to hear what new information is going to come. Why are there 11 rounds of discovery, but we're not seeing any of it? On this episode of About the Law, I'm Lainey Law.
And I'm attorney Andrew Myers.
And this whole case with the Idaho Fort has been a complete crazy mess. It's like we're getting some information sometimes, so now there's a gag order. What don't we know? What do we know? Do we really know the things that we know? It seems like every day there's new information coming out and new information being shut down. What's going on?
Well, we've kind of gone over some of this before, but you asked, what about 11 rounds of discovery? We're going to get into that in just a minute. But you know what? Let's take a look at why is it that so much stuff has been sealed. And the interesting perception I have is that with, a year now of documents being sealed and a gag order called a non-dissemination order and a real crackdown on letting no information out, I'm perceiving that maybe some of this will open up a little bit as we move into 2024. Has the wall of secrecy had a few cracks come into it? We have to go way back into the Wayback Machine to see that, there have been contacts with the newspapers. And so what am I talking about? This is what I'm talking about right here. This is a document that came out way back in June of 2023. It's a declaration of the defense attorney, Ann Taylor, in support of her third motion to compel. So we go backwards a little bit in time. Why did I bring this up? Well, we go through the documents and she explains why she's having to really push the state to get information. This is a common theme. You asked me, why are there 11 rounds of discovery? Well, back in June, Ann Taylor, the defense attorney, made an interesting comment. She said, I am aware of specific news reports in this case regarding Mr. Kohberger's DNA as published by the New York Times on June 11th, 2023. That FBI personnel worked with the profile that Othram Alab had produced, spending days building out a family tree that began with distant relatives. Wait a minute. Who in the case is talking to the New York Times? The New York Times sources have more information than the state has disclosed to the defense. This New York Times article generated intense media coverage and interest, the scope of which is explained in the True Scope report attached as Exhibit D. Now, that goes on and on and on. That goes into a lot of detail. But the telling thing about this document that's in the docket of the case is that the defense, which has a right to all of the exculpatory information, is having to read the newspaper to find out what's going on in the case. So that's the first crack in the case. The next crack in the case is, we go back to our slides. The lead prosecutor and the university are still talking. What? Now, we had gone over this before. The university president, Scott Green, had been quoted in the Spokesman Review communicating with the University of Idaho when they tore down the building. There's one of the last pictures that was ever taken of the scene of the crime, 1122 King Highway. You see the Santa Claus and the candles, and then the building was taken down a couple of days after Christmas in the year 2023. And we did this before. Thompson, the lead prosecutor on Kohberger's case, wrote in a December 22nd email to the university, and he wrote, based on our review of the Idaho case law, the current condition of the premises is so substantially different than at the time of the homicides that a jury view would not be authorized, Thompson wrote. We appreciate the University of Idaho's help in facilitating the investigators, gathering the necessary measurements, etc., to enable creation of illustrative exhibits that should be admissible and helpful to the jury. Andrew, we looked at this a couple of weeks ago. What's new about this? Well, what's new about this Remember last episode, we took a look at the book that was written by Scott Green, the university president?
Because of course, why? I mean, in the book's defense, at least it wasn't all about the Kohberger case, but I still found it interesting that it even involved anything about it. I think that's
Well,
crazy.
Well, here's the point. In that book, President Green pointed out that right after the murders took place back in November of 2022, they were meeting with the Moscow Police Department twice a day. Oh, they didn't learn any inside information, but they met with them twice a day, whether they were talking about what latte they wanted to get, or, if anybody believes that, I'll just leave that out there, trying to play it straight here. But they started out talking twice a day, and now, a year later, the president of the university is getting emails still from the lead prosecutor, Bill Thompson. So you've got to wonder, in that year that went by while we're all, being stonewalled and not being any information from the discovery or the motions or the declarations that are filed in the case, we are all subject to the stonewall of the non-dissemination order and things being sealed. Here, the president of the university, Scott Green, and the lead prosecutor, and who knows who else, they're talking, they're communicating, they're going back and forth. And at the same time that all that is going on, the defense, as we know, because we looked at it before, the defense is now looking to unseal some of the pleadings that they have filed. Here it is, the motion to unseal defendant's motion to reconsider orders, denying motions to dismiss the indictment, and in the alternative for permissions to appeal from the interlocutory orders. So you take those three things together, and I'm sure there's a lot more. My question is, at some point as 2024 goes along, is the wall of secrecy going to start breaking down, with communications behind everybody's back percolating up into the newspapers, with someone, we're not sure who, talking to the New York Times, and also an article appeared in the Boston Globe, and with the defense now looking to unseal documents? I guess the question that I'm raising, a rhetorical question, is how much longer can this total wall of secrecy continue? And I don't think it can last much longer.
I think that people naturally have a habit to want to kind of talk and like daily meetings, but no insider information is being passed. I think that's very unlikely, and I understand why it has to be said that no insider information is being passed along. But even when this case started before the gag order, it's like you're hearing this from someone, that from someone else. And even if people are supposed to be keeping things private, even if things are supposed to not be talked about, a lot of the times, I mean, that's just human relationships where it's just like, you're gonna, hey, don't tell anybody I told you this, but da 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 da. I don't really think that. I mean, it's going to be very hard to just keep everything behind closed doors, in my opinion.
It sure is. And the interesting thing about the fact that all this stuff has been sealed up is that in the top of all the discovery requests and at the top of all the motions, right before they say, and so therefore, in accordance with the rules of the state of Idaho, we are going to ask that this be sealed, they cite different rules. One of the rules that they cite, Idaho Court Administrative Rule 32. Well, what does that Idaho court rule that they always cite repeatedly actually say? Well, let's take a look. In the preamble to the rule, it says, the public has a right to access the judicial department's declarations of law and public policy, and to access the records of all proceedings open to the public. Wait, what? They are citing this at the top of all of their motions and their discovery requests. I think they've got the wrong rule, but they've cited it over and over and over again. And so let's take a more in-depth look at what that rule says. Here it is. Here is the Idaho Court Administrative Rule 32. I'll make it bigger so we can all see it, including me. Idaho Court Administrative Rule 32, records of the Judicial Department, examination and copying, and exemptions from limitations on disclosure. So here it is. This rule is adopted pursuant to the Idaho Supreme Court's authority to control access to court records as recognized in the Idaho Public Records Act, IC Section 74104. The public has a right to access the Judicial Department's declarations of law and public policy and to access the records of all proceedings open to the public. Yeah, I know I read that twice, but I think it bears repeating. This rule provides for access in a manner that promotes accessibility to court records. Wait a minute. This is the rule that they cite whenever they are seeking to seal these documents. This rule provides for access in a manner that promotes accessibility to court records, supports the role of the judiciary, promotes governmental accountability, contributes to public safety, minimizes the risk of injury to individuals, protects individual privacy rights and interests, protects proprietary business information, minimizes the reluctance to use the court system, makes the most effective use of court and clerk of court staff. Are you reading that down there in South Carolina? Provides excellent customer service and avoids unduly burdening the ongoing business of the judiciary. That's kind of interesting. In the event of any conflict, this rule shall prevail over any other rule on the issue of access to judicial records. And I've seen a lot of people, show these motions and discovery documents and declarations, and they just read right over Idaho rule. Well, there it is. It favors access to the Judicial Department's declarations of law and public policy. Okay, to be fair, we go all the way to look how long this rule goes on. All the way. We'll go all the way to the bottom because I will be fair and show you Section F.
It's like ironic because this is like one of the most legible legal documents in existence where it's like very clear line by line.
Right.
And then it's still illegible because it's like miles long as a paper.
Oh, yeah. I think we're
17 pages.
17 pages. Yeah. So we're on subsection F3. I believe F3G. Now, okay, the bottom of the rule, after they say how everything needs to be open and out in the light and that the public policy of Idaho is to show that everything is open, to be sure, here you go. The exempt is this. Court records exempt from disclosure. Exempt as provided in paragraph H of this rule. Court records specified below are exempt from disclosure. Any willful or intentional disclosure or accessing of a sealed, shielded, or exempt court record not otherwise authorized under this rule may be treated as contempt of court. So these are the things that are exempt from disclosure, and we won't waste our time on stuff that, is logical but not pertinent to what we're talking about. We go all the way down to juvenile records. Of course, you wouldn't want juvenile records to get out. Records relating to consent required for abortions for minors. Of course, you don't want that. A lot of stuff in here is exempt, and we keep going, and I should have put in my notes how far down we have to go, but I think here we go. So this is exempt. Before a court may enter an order redacting or sealing records, it must also make one or more of the following determinations in writing. So the determination has to be in writing. We know that it is necessary to temporarily seal or redact the documents or materials to preserve the right to a fair trial. So there we go. This is the rule that they are citing, and that's really all it says. It goes on quite a bit at the top of the rule, as I pointed out and read twice, that the policy of the state of Idaho is openness, complete openness in the court system. But you got to go all the way to the bottom of the rule, to see that it is necessary to, and look at that word, temporarily seal or redact the documents or materials to preserve the right to a fair trial. Now, in a previous podcast, we talked all about the Nebraska Press Association case in which the U.S. Supreme Court said, sure enough, there is an absolute right to a fair trial, but there's also an absolute right for freedom of the press, freedom of information. And the court said neither one of those two rules take precedent. They're both equal rights. So I don't know. I just thought that was interesting that the rule that they have been citing so much has one sentence about preserving the right to a fair trial, but it goes on and on and on and on at the top about, the public has a right to access the judicial department's declarations of law and policy. So,
very ironic. It's a very ironic thing that they keep citing this in a trial that's all about secrecy and gag orders. And, obviously it has its points to where it's applicable. But I mean, I think everybody, even the people that don't live in Idaho, want, information out. I think a big reason why we're here talking about it on YouTube, why everybody's interested in this case, is because there's no information. So a little counterintuitive. I don't know.
So the actual policy of the state of Idaho, as codified in their court rules, and this is an administrative rule, the actual policy of the state of Idaho is that the public has a right of access to the judicial department's declarations of law and public policy. Now, we're not seeing that a whole lot, are we? So we'll go on to red flag number 3. Yes, 11. Yes, 11 rounds of discovery from the defense. And it goes on and on. We're getting more and more discovery. It's all redacted. And all we can do, since it's been sealed, and even though the administrative rules states that the state of Idaho's policy shall be to make things public, all we can do is really speculate. So now, we know that one of the issues that the defense and prosecution fought over for some time was this IgG, investigative genetic genealogy. It goes all the way back to the summer of 2022. The defense attorneys said, wait a minute, you found Kohberger in part through a process involving investigative genetic genealogy. We want it. We have a right to it. And the prosecution said, oh, no, we didn't really use that in a sense that we're going to be presenting it at the time of trial. So we don't have to give it to you. And both sides briefed it in lengthy motions, and there was a hearing, half of which was public, half of which was private. The judge finally broke down and said, okay, give me the material by December 1st and I'll decide. So that happened. The material was supplied actually on the last day of November. And the judge took a look and over the holidays decided it. And then a court order came out saying, well, you can have a portion of it. Wait, what? You can have a portion of it? So we talked about that in a previous episode about how that will prejudice any expert that the defense has. Mm-hmm. But I only mention that to point out that if the defense had to go to that length, to that extent, to dig something out, and they only got a part of it, what is in these discovery motions? I mean, what could they possibly be looking for? And I was thinking about it. I know I shouldn't think too much, but I was thinking about it. And there is a rule on discovery and what they're entitled to get. So I'm thinking, and this is my speculation. That's all it is. What could they be looking for in these discovery requests? Well, it's been said that they tore down the house because they had already gotten everything out of it, measurements, and they're going to do a LiDAR or video representation of the house. Well, that's fine. In a lot of jurisdictions that I am familiar with, if you have a day of the life or a video representation, you've also got to submit your raw video. So what did they do, and what did they edit it into so that the jury would have a limited view? So that's one of my ideas as to what they might be looking for in discovery. Photos of the crime scene through the multiple law enforcement visits. Now, we know the law enforcement has been over there many, many times. Right before they tore the place down in December of 2023, law enforcement went in there again and took photographs. Did they produce them all? Did they give them all to Ann Taylor and the other defense attorneys? Or are the defense attorneys having to fight to get them all? Seriously. I mean, these are some of the things I can think of. And I'm sure the attorneys and others in the audience can think of other things that they're fighting over through 11 discovery requests.
I think a lot of people, I can't even imagine working in these conditions. I know you have more of the legal, expertise and background to know what that's going to be like. But like you said, I feel like it's not fair. It's not fair to the defense to not even know what they're working with.
Well, one of the other things that the rules, and we looked at one rule, I'm not going to bore our audience with another Idaho court rule, but one of the other court rules specifies the things that are proper targets in discovery. And one of the things is test results. So as they fought back on the IGG, is the state of Idaho prosecution also fighting back on test results? What kind of test results could there be? Well, not only blood analysis. What about blood spatter analysis? That is a science. Anybody that reads true crime understands that blood spatter analysis is something that helps investigators figure out what happened. What about other tests? Tests on the knife sheath. Forget about the touch DNA. What about other tests on the knife sheath to determine if some expert says that knife was actually used or maybe it wasn't? Those are only a couple of ideas, figuring out test results. What about this whole thing about the vehicles? The vehicle, at first it was said to be a 2011 to 2013 Elantra. Then the FBI expert, his only job, he's got one job, just like the guy that does the fries at McDonald's. He's got one job. One job is to identify cars. Oops, it wasn't a 2011. It was to 2013. It was a 2015. Well, that's subject to discovery, and other podcasts have gone way deep into detail, which we haven't, because I try to stick mostly with the legal, but there's some other people that have done an excellent job showing the different videos and photographs of this vehicle that Brian Kohberger is said to have been driving. Some of them are good. Some of them are as fuzzy as the fog in London. So these are just some of my ideas. There've got to be a ton of other ideas for things that the defense has to dig away at the state for behind closed doors to figure out what's going on in the case.
The whole idea of it is just absolutely insane. I can't even imagine. Like I said, it's just like, I don't know how you work under these conditions. I don't know how you...
I've never done a case like this. In the civil law, we do fight for discovery sometimes. But this is something else. So now,
especially with something so serious with the firing squad, at risk.
Exactly.
Yeah.
So our final red flag today is about discovery battles. I have been asked, doesn't the prosecution just have to turn this stuff over in an ideal world? Yes, they do. Court rules in the United States give prosecutors a constitutional duty to disclose material evidence that is favorable to a defendant. And people that do this every day call it Brady material. If you get a new defendant and you go to court, you just ask the prosecution, when are you going to turn over the Brady material? And they call it that because it's based on a United States Supreme Court case titled Brady versus Maryland. And for the attorneys in the audience, if we have any, yes, that decision has been refined and extended and commented upon many, many, many times, not only in the U.S. Supreme Court, but also in the state courts around the state. But the basic idea is that, yes, if you got exculpatory evidence with respect to the defendant or with respect to any of the witnesses, you've got to turn that over. And suppression or failure to provide exculpatory information, whether it's intentional or a mistake, that can support a defendant's claim for a new trial. So it's just something else in this case. It's just something else that the defense has had to file 11 discovery requests. We've told you about what they might be looking for, and we've told you what the state's duty is. And going back to the very first topic here, at some point, the veil of secrecy is going to lift, whether it happens at trial or, as I guess might happen, maybe some journalists will start doing their job out in Moscow and Pullman, and maybe we will learn some of this. But it's just beyond belief that the case has gone this long, and there's just been such a veil of secrecy.
Mm-hmm. And like how you said, like hopefully some journalists will do their job. It's interesting because when you think about how things used to be, even 20 years ago, it's just like it was like the news was out and about. But now that everything's all digital, I mean, we're living in a post-COVID world right now where people are scared to go out and go get information. And a big reason why anybody's here watching this video right now is because they're trying to go out and get that information. And the fact that they're having so much trouble getting this information that they need, especially with the defense, how you said it might lead to a new, like, being able to argue against the trial. I feel like this, no matter the outcome, is going to be something that we're going to be hearing about for a long time now, even though people are probably thinking, but it's been going on for so long right now. I think this is still only the beginning.
Yeah, there's case law, United States case law, that was promulgated after the Brady case that does point out that if a case goes to trial and if the state withheld either intentionally or inadvertently, doesn't matter if the evidence wasn't presented to the defense can ask for a new trial. So my final thought in this vein today is that sometimes we get so deep into these vicissitudes and rules and things that are happening that we forget that this case is about four young people. They were 20, 21 years old. All three of them were students. One of them had just gotten a job and was on her way to a whole new life. And we forget that this case is about Ethan Chafin, Xana Kernodle, Kaylee Gonzalez, and Madison Mogan. We forget that the case is about these four young people. And I just wonder, what are the families and the parents and the friends thinking? We'd like to think it's horrible that something like this happened. It's just a horrible, horrible thing, unthinkable that this happened. But at least when and where I grew up, you would always think if something like this happens, the judicial system is there to find the defendant, incarcerate the defendant, give him a free, fair trial. And if it's him, that's it. If it's not him, move on. But what was the families? And I know some of the families of these victims, some of the families have spoken out. Others haven't. They don't all agree. But I just wanted to point out before we go on that that's what the case is about. The case shouldn't be about all this other stuff we talk about and we all center on every single time. So I just, my heart goes out to the families and friends of those four victims.
Yeah, and I think that's an important part to bring up, because even though I say that this feels like it's going to be this is just the beginning of all this trial and everything that's yet to come for these victims' families, is just like, how painful is it, like, to have to experience all this, and how painful is it now with the gag order, like we mentioned. It's just like, I feel like a big portion of the kind of media hysteria that we've been seeing is, because they're trying to keep things quiet. And it's really sad to just think about how the victims' families,
it's kind of a parallel to the Delphi case. Little Libby and Abby disappeared and were victims of a murder way back in February of 2017. And that one's been 7 years. What must those families think? What must those families think that they lost their two little girls just coming into their teenage years? And, so many horrible things. And we've talked about that in another episode, and we're not going to get into it now. But just what must people think when the judicial system just, ends up, spinning circles like that?
I mean, even when you think about with this Kohberger case, what if Kohberger is found not guilty? Like, what then? Is just like all this time that's been waiting, talking about this trial. If he were to be found not guilty, then all that time is lost to finding, the actual killer. Is just like, when is it going to reach a point where these families are going to be able to confidently feel safe? The trial hasn't even begun. It's been a year.
Yeah, that's tough. It's real tough. Really tough in both of those cases and some others. So, all right, on that note, why don't we move on and do our new feature? I guess it's not new anymore. We've been doing it for about a month of reading comments.
Even the channel's new. We're all new. Everything's new.
We get a ton of comments. It's good, bad, indifferent. Well, no, we don't get any indifferent ones. Do you want to go first?
Sure. So this isn't one of the ones that you pulled. This is one that I pulled separately, and this is going to be a little confusing for some people who may be new to our channel. But Jamie Fio 643, my girl, says, Lainey, you need to get a PBA card. LOL. I'm from New York. Lots of families are cops. Live in Charleston, South Carolina now. Husband works for police department here too. But I get your point, but more about New York State troopers. And now you're probably wondering, what the hell does this even comment mean? I had a very controversial take apparently in one of the episodes where I said New York cops are douchebags. And Multiple people have left comments saying, Lainey, you can't say that. Jamie gets me. Jamie's married to a cop, and my cousin's a cop. My cousin's a New York corrections officer. So it's just like the ones from who are from New York. If you get it, you get it. If you don't get it, then you're not from New York. But I do want to say, Jamie, your comment made me realize I do have a PBA card, and my cousin gave it to me to fill it out for those of you who don't know. And apparently a lot of people don't know this, but I don't know if it's the same in other states, but in New York, if you know a law officer, you can get like a card or a sticker, and then you get pulled over. They see your sticker, they see your card, and they know you're like a friend of the police. So they give you a less hard time. So, I'm just putting that out there.
Okay. I'm going to read a couple of short ones. Here's my favorite one. And this is from, I think, our regular viewer and commenter, Caddy Crime Ghoul. I love the name. And she says, Law Offices of Andrew D. Myers. The background is a courthouse. It is the John Adams Courthouse in Boston, Mass. Yep, you're right. I had asked, I think, in 2 previous episodes, maybe 3, what is the background that we have here? And no, it's not just a stock, StreamYard or whatever background. We ventured out, and that is the courthouse in Pemberton Square. At least that's what they used to call it many years ago in Boston. It is, in fact, the John Adams Courthouse. It is right in the middle of Boston, across the street from Center Plaza and City Hall. And that's where a bunch of courts are in there, but primarily the Suffolk County Superior Court sits there. And the building to the right, which is out of the frame, is the building that has the Massachusetts Supreme Judicial Court and the Appeals Court. So you got it right. Thank you.
Thank you, Caddy Crime. We see you comment on our videos. We love you. Shout out.
Let me read another really quick one. And I like this one too. Your channel. Oh, this is from Sanjay Varma. Your channel keeps getting better. Nice to hear this information, which is not being reported elsewhere. Thank you. Well, thank you, Sanjay.
Thank you. That's very nice.
Yeah.
I have one from Alpine Arts over here, which is, thank you for reading my comment and responding. I found such a great channel that day, and I'm excited to see you'll be speaking with Pete at Murder Metal Mayhem as well. Thanks again. Thank you, Alpine Arts, and we're glad that you guys appreciate us reading your comments. We didn't know how it'd go over initially, so it's really exciting to see that people are not only enjoying the channel, but enjoying our commentary on what you guys have to say.
Yeah, exactly. I've seen quite a few creators criticize people writing books before the case is completed. But my question to you guys is, how is it any different than making videos talking about the case before its conclusion? For me, I don't see much of a difference other than the way the information is being disseminated. I also think the defense is cherry picking information that is favorable to their client. If you want transparency, why not request everything to be unsealed instead of only your motion to dismiss? I hope the judge denies the motion and recognizes this ploy for what it is, an attempt to sway public perception in regards to their client. So,
it's a lot to unpack.
Yeah, this is the mad chatter, and that's an interesting comment. I would only say that, we own the courts. Mm-hmm. Yes, I said it. We own the courts. The judge and the administrators are our employees, and we have absolutely every right to know what goes on in there, to the extent that they want to protect the integrity of the investigation and the make certain that the defendant has a fair trial. They're absolutely right. But
I did want to touch on too, because they're like, oh, well, why is a book different from a YouTube video, which is ironic because I feel like I made this point on that same video where it feels like a book has a bit more permanence versus on a YouTube channel. It's like something happens and we can issue a correction. A book, is the book really going to be corrected? Is there really going to be a sequel to the book? Versus as we're sitting here making YouTube videos, as you see, we get feedback from you guys. We can update in real time. So that's a little bit of a difference that I see, where it's like things might not always be right on the news, but when things change, you find out.
Yep, absolutely. And here's another one. As for the jury proceedings being secret, Firstly, I think the grand jury should be abolished for several reasons that are not worth mentioning now. Well, come on. Tell us why. And secondly, and since the grand jury exists, only jurors' names should be kept secret from the public, not from the defense. Everything else should be public. Well, yeah, you're right that the grand jurors' names should be kept secret, but I guess they're going to keep fighting this business with the grand jury, and we do not know as we sit here today what's going to happen to that motion. But good comment. Thank you.
I have one comment here from a nice giraffe photo. Roses Kern 6073, which I saw you left a couple of comments and I was flattered but concerned. Who is Lainey Law? Everything about you. Come on, share. So we were actually just on the Metal Murder Mayhem podcast with our MMM podcast with Pete, and I talk a little bit more about myself there. So if you're interested in learning more about me, be sure to check out Pete's podcast.
But I'm not telling you anything about me, so there.
Private. I will see. Maybe you guys got to start watching all of our videos and not just the Kohberger videos. And then maybe for our members or something, we'll start doing more down to earth personal videos or something. I don't know. Let us know what you think if you want that kind of stuff.
Yep. Okay. I'm going to read one last one. And this is from Kay Hawkins. And Kay says, nothing you say places BK in the house or the car. It's all conjecture or what law enforcement theorizes. The probable cause affidavit is totally theory as to what law enforcement thinks happened, nothing more. The only link law enforcement has is trace touch DNA and partial DNA, which is the most unreliable. As far as alibi, Kaylee's boyfriend said he was asleep. Is that any more credible as BK driving around? Dylan Mortensen had no alibi before or during the murders. JS, that would be Jack Showwater, left town to drive 5 hours to his parents' place. He wasn't even interviewed, except law enforcement spoke to his parents over the phone. There is a video of law enforcement stating this. He left along with his parents days later to Africa. So yes, some were cleared too soon with less of an alibi than Brian Kohberger. So that very succinctly. I keep putting I moved my camera and I keep I moved my configuration here and I keep putting my papers in front of the camera. Maybe some people like that, but I don't know. But this person summarized the thoughts of a lot of people. I'm not saying it's right. I'm not saying it's wrong. I'm just saying that summarizes the thoughts of a lot of people. But I have a question. I've often thought about this. Dylan Mortensen had no alibi before or during the murders. Well, in a sense, I guess that's right. I mean, what alibi do you have when you're sound asleep? I mean, I can't be accused of a crime that happened last night in Chicago because I was sound asleep, not in Chicago. But if a crime occurred, closer to where I live, that's my alibi. I was asleep. So, I mean, I don't know. I think it's a reasonable alibi, not having been there, knowing nothing seriously about, what happened in that house. And nobody does really. That's her alibi. She was asleep, except for the time that, according to the probable cause affidavit, that she got up, she opened her door 3 times. She saw the guy with the black face mask and the bushy eyebrows. So I don't know. We just don't know.
Chaos. All right. So that was your last comment. I have my last comment here that I need to give a special honor to. This is about our conversation about how the university had daily briefings with the police and didn't have any insider information. So this is from JMD 12-12-7, and it says, excerpt from daily briefing, university. The crime was committed by an outsider, right? Police. University. The crime was committed by an outsider, right? Police. And then last one, university. The crime was committed by an outsider, right? Police. That kind of goes with like how we were saying. It's like, what is the daily briefing? How are you talking daily? Have no insider information. Like, what is going on there? It's just quirky.
Yeah, that was something that's, I don't know, what were they talking about? On the one hand, I can kind of understand. At one point, I did live in a university town briefly, for a couple of years working there, not as a student. And I guess I can see the administrators, if something like this had happened, and thank God it didn't happen, I guess I can see them, being concerned. But 2 daily briefings a day, and with the with the university president. I mean, universities are just like the government. I mean, there are levels and levels and levels and levels and levels of bureaucracy. And there's so many different people with so many different jobs. Many of them are bean counters. Many of them are, they work with the students. Some of them work in public relations. Some of them work in outreach. Some of them work with the alumni. Some of them work on fundraising and keeping tabs on the money, the endowments. So, I mean, administrations are so huge that it's hard to believe that the guy that's at the top, the top administrator, the president of the university, that he is meeting with the police department twice a day. He doesn't have any inside information. But yeah, wait a minute. The guy that committed it was from out of state, and he wasn't a part of the university. So I hate to say this, but it doesn't have the ring of truth.
It does not pass the vibe check.
Anyhow, that's this episode. Thank you for joining us. Thank you for being with us. Please like and subscribe. And I'm done. Lainey, any final thoughts?
No, just thank you guys if you watched until this point. Be sure to let us know you watched until the end, and we'll see you in the next one. Bye.
Adios. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. And I will not be here next week because I will be doing an investigation of the tunnels.
And that's that.